Ronald from Ronald Ready Law, and today we're going to be talking about Donald Trump and his brand new federal indictment. It's in the Southern District of Florida here, and specifically as a lawyer, what I'm going to talk about is the implications of proving each element. What are the differences from this handling of classified information versus what some other people have done, namely President Biden as well as Hillary Clinton? And if you're interested in some of the legal technicalities of proving each element, as well as what the time frame looks like for an actual trial or a conviction, and how that relates to the election and when that timing is going to occur, stay tuned as we walk through it. All right. So, I think at this point, everybody has seen the fiasco or the spectacle that is Trump arriving in Miami. He pleaded not guilty today to all of this, but um, he has 37 felony counts. They are, really wide ranging. I think that generally he took classified information from the White House. He then had those documents recklessly stored, and then he actually allegedly showed them to people with a dialogue that seemed to convey that he understood it was classified and he probably wasn't supposed to do this. And I think that's a real distinction about these allegations versus what are alleged in some of the other classified documents mishandling. Um, but we're going to talk about one in particular. This is under the Espionage Act. This is 18 U.S. Code 798. Um, or see 793, I guess. What is 7? Um, and let's go through the elements. This is 18 U.S. Code Section 793, gathering, transmitting, or losing defense information. And the elements are here with the intent or reason to believe, copies or takes any negative map, model, instrument, anything connected with the national defense, whoever having lawfully possession of access to, um, or the advantage of a foreign national, delivered or transmitted the same to any person not entitled to receive it, or willfully retains the same and fails to deliver on demand to the officer or employee of the United States. And this one expands more into the conspiracy. If two or more persons conspire to violate any of the foregoing, they will have that. And, beyond some of these large details, I want to go into that exception about the knowingly. And it really speaks to Trump and the alleged testimony that he knew what he was doing was not kosher, or, I don't want to say illegal, but he knew that he shouldn't be doing it. And if those witnesses do testify in his trial, it's going to come down to a credibility test if Trump denies that statement or if he denies making it. And again, when I look at it, I think that those witnesses don't necessarily have an axe to grind against Trump. They're not somebody like Michael Cohen, a scorned attorney. They're not a clear political opposition member. It's like some of the women that were testifying against Trump. And that makes it tough. If I'm a reasonable person on the jury, I'm going to have a hard time taking the credibility of the defendant eyewitness testimony that I didn't say that versus somebody who really, on its face, I don't know their true motivations, but on their face, they seem less motivated than a lot of the other witnesses that we saw in his other cases. And so for that reason, I do think that he has met, at least based on the allegations. If they can prove those allegations, then it looks bad. It looks bad for Trump that he, would eventually be guilty. Now, let's go to that second part. When would this trial actually happen? Because for federal cases, especially large, complex ones that have 37 felony counts, it's not going to be a quick process. And I think that everybody likes to spin up in this. And beyond just the distraction, Can Trump delay or extend this trial and this criminal case until 2024? I would say yes, emphatically, easily. All it takes is a couple motions that are routinely granted. It doesn't matter if the other side opposes, but this is a big case. This is important, and nobody is going to be set for trial until 2024. So if you're initially set for trial for 2024, you can still ask for extensions as you prepare your defense, as you seek to negotiate with the prosecutor's office, the district attorney. And what's really interesting is that this will almost definitely get pushed if Trump wants it beyond the 2024 election. If he wins, which very possible. I mean, I'd say right now he's a front runner. DeSantis is in second, but I wouldn't even call it a close second. And so if Trump is the nominee and he does win, which is, I wouldn't say it's a majority, but strong chance of that happening, then can he pardon himself if he does get convicted of this? And again, I would say the answer is yes. Not a lot of precedent for that, but there is nothing prohibiting that either. And so we have a really interesting case where it's in the defendant's interest to delay. I guess that's not interesting. But if he delays, the outcome of this specific trial really becomes less important. It's unprecedented. I think people love to use that word with Trump, that everything is unprecedented, and it is. It's really true because of this media fascination and the TDS symptom that so many people have. They get so worked up and angry about this guy who is not president anymore, but it just invokes a very, very visceral reaction on both sides of the aisle. So I don't know where your politics stand, but the reality is that the elements of the crime, at least some of the charges, seem to be met by his own admittance. There are, pretty damaging photos. Although I'll say, I'm looking at this one now. There's a ballroom photo where he kept it. I don't see what the difference is being stored in Mar-a-Lago, which is his residence. And, they make a big deal about the amount of traffic and, this was a highly trafficked area. That really shouldn't make a difference to the elements of the crime in terms of mishandling classified information. Joe Biden was storing classified information in his garage, and it was heavily trafficked because he had reporters. He had people, he's doing a photo op with his Corvette, and people took pictures of those boxes. So I really failed to see what the legal implication of the storage location. And the media is making a big deal about it's being stored in the shower, it's being stored in a bathroom. It's all fair game. I don't think it's good, but everybody is doing that. And so as an element of the crime, I don't think that proves anything. That doesn't make it more at risk. And you still have to prove beyond a reasonable doubt that it was given to other people. And that, storage location, I think that the quote unquote recklessness of storage is exactly the same. Now let's compare what Trump has allegedly done compared to Hillary, right? As much as people hate Trump and have such a reaction to Trump, there's that same contingency on the other side that still has the but her emails. And for the emails, I think, again, in some ways it's worse because it's digital format and it could be very easily hacked remotely, versus the physical storage or reckless storage online. If it doesn't have certain levels of security, which she actually stripped, right? She had her aides, she directed her aides to strip the headers of classified notations of the files so that they could be emailed on an unsecure server. That has the potential for a lot more exposure. So if you want to talk about recklessness as an element of the crime, it's a pretty low factor in determining whether somebody is actually guilty of this crime, which again, will remind you, has a very high burden beyond a reasonable doubt for a criminal conviction. This is not a civil case, which if you see my other video, I talk about these civil lawsuits. All you need is more likely than not, 51%. When you get into criminal and you're talking about beyond a reasonable doubt, that's got to be in the 90s. That's got to be 95% sure that this thing really happened. And the storage aspect to me really should be a non-issue. They should really focus on the eyewitness or the participant's testimony, subject to cross-examination, all of this. And Trump again could, of course, testify on in his defense. But what really bugs me, I guess, is they are taking, and they is the media. They're latching on to these little morsels. You could say the same for some of the special prosecutor, but the fact that Hillary had this information and we couldn't prove that it was shared, we couldn't prove that it was given to other people because she destroyed them all. And if you want to be very technical, because I'm a lawyer, and being technically right is the best kind of right, but she didn't destroy her computers. She didn't use the bleach bit. She instructed her aides. And to the extent that that's a useful distinction, I will say Hillary destroyed all of that. And as a defense, people are saying, well, she did that before the subpoena. And so she wasn't under notice that there was possibly an investigation. Therefore, she's not guilty because they couldn't find any evidence of wrongdoing. And I hate to say it because it is fully her right to do it, but in the court of public opinion, and that's what we are. We're a talking head on YouTube now. It absolutely looks guilty. And it absolutely is the acts of somebody who did destroy the information or who did share the information. And if you had evidence on those devices that it was shared inside in the exact same manner that Trump shared it with somebody, that's exactly what you would do. You would smash them all, you would bleach bit, you would um, take a lot of steps to destroy the physical evidence. And maybe that's just the difference, right? If there's a physical document and we show it to somebody, there's a lot of evidence about where it was stored, how it was showed, all of these things. Whereas if you have a document, say on your iPhone, and you just show the screen to somebody, that is the exact same level of disclosure, and the same crime is being committed if you intentionally and knowingly do it. However, it's a lot harder to prove. You don't have these physical document custodial issues that a physical document has, like in Florida, versus if you just show somebody on your phone while you're elsewhere. And it's hard to prove who was looking at a smartphone and exactly what you were looking at on the document. And again, I think it's going to come down to a lot of that very specific testimony, because Trump certainly is going to have classified information right next to non-classified information. And again, I'm not an expert, so certainly they're going to testify about the markings on the document, whether those would be visible, whether there were other papers obscuring it, whether they clearly could tell that this was classified information, or what basis they have to believe it was, because it very easily could have been a document which was not classified but looked very similar. And so again, these cases that turn on eyewitness testimony, it comes down to their credibility, which, as I mentioned earlier, I think these witnesses do have some concern about being credible. They don't necessarily have an axe to grind, although that may come out in cross-examination, all that sort of thing. But at the end of the day, it is really critical to understand these individual elements. And as a lawyer, based on the allegations, they seem to have a lot of the evidence to prove it. However, can he delay his trial, delay his conviction? Absolutely, yes. I mean, even if he goes right up to a 2024 trial date, he can fire his lawyers and say, Your Honor, I need an extension of 3 more months to hire new counsel. And there's not a judge that's going to want to convict a defendant in this manner without having counsel. And so, whether he gets 3 months or 2 months, whatever, he is going to have extensions. There is no speedy process when you talk about this justice. And so, other than just being a big distraction for Trump, because now he's facing a war on multiple fronts, and it's not going to be pleasant to be shuttling back and forth between court appearances or talking to lawyers, planning things while he's trying to run a national campaign. But can he delay it? Can he wait for that conviction until he finds out if he wins? Absolutely, and that may just be part of his trial strategy. So smash that like button if you appreciated this commentary and hope it was helpful for understanding a little bit of the legal procedure and the timing behind this case. And we'll see you next time.